Well, good evening, and thanks for joining us for another episode of Canada, a User's Guide and Owner's Manual. We've got a special guest tonight. Looks will be a bang up show, I think, tonight. But I'll start off. I spent 15 years in the Ontario legislature, and early on, watching this machine cranking out new laws every day. Um, and I asked myself, like, does this machine ever stop cranking out laws? Um, and uh, there's an old adage, everything in moderation, but there didn't seem to be much moderation. And when I look back and say, you know, a few thousand years ago, we only had 10 laws to deal with in societies. And now in Ontario, we have over 400,000 regulations and laws from our province. We also have a similar number of laws from the federal government. And then we have a whole host of other and various municipal laws. Um, can we have a little too much of a good thing, I think? Anyway, tonight we have Bruce Pardy joining us to examine the rule of law, our Constitution, division of powers, and a host of other topics. And we've been getting a lot of questions. We're going to try to get through them all. But stay tuned as we bring people into the stage and let's see what happens. Can we turn that shield that is to protect our freedoms back into a shield and not a sword that the government's been using on us? Stay tuned.
To prevent injustice. The law is meant to prevent injustice, not create it. It is meant to be a shield to protect our freedoms, not a sword to cut them away. But during the last 4 years, we've seen all our Canadian governments use the law as a sword against us. At the top of those laws is our Constitution, meant to restrain and prevent governments from abusing our freedoms. In this week's edition of Canada, a User's Guide and Owner's Manual, I'm joined by that great Canadian law professor, Bruce Pardy, who was at many of our No More Lockdown rallies, and who was in Ottawa and honked his horn loudly in defense of freedom. Join us this week as we examine and dig into our Constitution, the rule of law, the difference between statute and common law, the division of powers, and much, much more. Bruce Pardy, Lee Stewie, and I will be examining how our shield became a sword and how we can pick that shield back up again here in Canada. If you'd like to help out, donate to this production, or have a question, visit nomorlockdowns.ca and stay tuned for another edition of Canada, a User's Guide and Owner's Manual.
Well, joining us tonight, I'm going to introduce the fabulous and wonderful Lee Stewie is joining us tonight as well. Lee, are you there?
I'm here. Randy, how's it going?
Not bad. Been excellent. Oh, yeah, I should have said it's been a real excellent. I did, we booked this time with Bruce a while ago, a couple of weeks back, and then of course last week I found out that I'm no longer an accused felon in Canada now, and my criminal charges have been stayed as well. So it's been a pretty good week lately.
Yeah, I wanted to actually congratulate you on that. For those tuning in, if you didn't hear, Randy, your charges were stayed, which is huge news. Yeah, congratulations on that. It's an epic W for Mr. Hillier
and
Canada as a whole as well.
It's a great thing, and I do want to make mention. I had a fabulous, wonderful lawyer that I hired for this specific argument on the Jordan application. His name's Mark Ertl from Ottawa, and I can't thank him enough as well for his marvelous delivery of the facts in the arguments. So thanks to
So I
Mark.
think before we get started here on the stream, I'm just going to go through some housekeeping as usual. We're on episode 5 now, and very exciting stream. Bruce Pardy is going to be here, and he's going to be answering some of your questions, and that's going to be at the last portion of the stream. Both Randy and Bruce will be answering your questions that were submitted to No More Lockdowns / Ask a Question. But if you didn't get a chance to do that prior to the stream, you can send in a super chat. I think we're on Entropy and YouTube, and we'll get to all those questions at the last portion. There's also a Twitter space at 9:30 after this stream, so you can interact with Randy, and Bruce will be there as well. And if you're watching this on the replay, you can also go to Randy's website, No More Lockdown / donate, and yeah, send in a little dono because you're this is self-funded. This is a self-funded, no sponsored live stream.
We're not getting any government subsidies on this one.
No, we're allowed to say whatever we want.
And also joining us is my friend and outstanding farmer from Glengarry, Sean McRae. Welcome to the show, Sean.
Thanks, Randy. And I'd like to also congratulate you on representing yourself and against the Crown and succeeding. It was I was, on your left hand there for the most of the summer, half the year, and I'm super pleased with the outcome.
Thank you.
I mean, the system wanted to knock you down, and you're not that easy to knock down. So, congratulations.
Anyway. Thank you, Sean, and thanks for being there and having to watch all those painful videos and all the evidence from the Crown. Now,
it was enlightening.
Tonight is a wonderful fella. I've had the good pleasure of knowing Bruce Pardy for a number of years. He's one of the foremost Canadian law professors in my books, and he's been at many of the press conferences that we held in Ottawa. He's attended many No More Lockdown rallies, and he's just been a fabulous voice for freedom in the law, in academics, and in the law in Canada. So thank you very much, Bruce, for joining with us tonight.
Oh, thanks, Randy. Thank you for having me. And listen, I want to add my voice to the congratulations that you're receiving. What you did took a lot of courage, and you did stare down the machine, and that's not easy to do. So very well done.
Well, thank you very much, everyone. And I, of course, I could not have done it without all the great support from across the country in prayers, support, and financial assistance. Taking on the machine, it's a lot easier when you've got great people with you. So thanks. So listen, Bruce, I think maybe we're going to start off with, and one more thing. There's always one more thing before I turn it over to Lee. And that is next week we've got Brian Peckford on the show as well, and we'll be digging a little bit deeper into what went on as we developed the Charter of Rights and Freedoms. And Brian Peckford is a former premier of Newfoundland and the last remaining premier who was there to watch all the goings on in crafting up the Charter of Rights and Freedoms. So anyway, and maybe we'll start with give us a little snapshot of the hierarchy of law, Bruce, if you don't mind, and what your views are.
Sure. Okay. So one thing that COVID did for us is reveal the way the legal system actually works. And that's not what a lot of people think that it was, and what it should be. So first thing is, let's talk about the hierarchy. We have a constitution, and we have statutes, and we have common law. And those things coexist, of course, but there's a hierarchy. And as people would probably know, the Constitution is at the top of the hierarchy. When a constitution and a statute conflict, the Constitution prevails. When a statute and the common law conflict, the statute prevails. What's the common law? There's a lot of confusion about what that term means. Common law is very old law made by courts over a very long period of time, hundreds of years. But it's also current law. So if you today had a dispute about a contract or a piece of property or a negligence claim or something of that nature, chances are you'd be dealing with something from the common law. In other words, the rules that apply wouldn't be in a statute. They'd be in cases, case after case after case after case. And a lot of the law that we have is still common law. We live in a common law jurisdiction. Now, that does not mean that most of our law today is common law. It's mostly statutes and regulations and policies and all that nonsense. But it's still there, and it is still the basic, if you like, the foundation of our legal system. So if you have a statute, one thing a statute can do, the legislature can reach in to the common law and it can change it. Let's back up a bit. When a king in English history first established common law courts, what they said they were doing was sending these magistrates from place to place, from community to community, to apply the local law, that is the common law as it existed at the time between the people who lived there. That's where the word comes from, common law. But as time has gone on, it has taken on rules of its own. That is, it is now part of the structured system of rules that constitute the law of the nation and of the province. And so that's the hierarchy: Constitution, statute, and common law. Now, just before I finish, just one more word about all those laws, Randy, that you mentioned. All the huge number of laws that we have, both provincial and federal and municipal. The biggest part of those laws are not statutes, and they're not common law, and they're certainly not constitutional law. Most of our laws today are made by what we call the executive branch, that is the administrative state. They're regulations, they're policies, they're guidelines, they're directives, they're orders, and those are very much more difficult to track. You can't just pull the statute book off the shelf and read the statute, because the rules are not in the statute. They're in the secondary legislation, as it's called, made by all of these ministries and agencies and commissions and ministers and officials and so on. So we have reached the point now, and this has been the case for a long time, but we've reached a point now where it is very difficult, if not impossible, for anybody to know what the law is, especially the lawyers. Lawyers don't know what the law is. What they are able to do is to go and figure it out. But if you ask a lawyer about an area of law that they're not practiced in, they'll really have no idea unless they go and have a look. So we are drowning in law. And there's a quote that I like, that I mentioned to Randy earlier. It goes like this: dying societies accumulate laws like dying men accumulate remedies. It's a quote from a Colombian philosopher, and I think there's something to it.
Yeah, well, I think there would probably be a lot of people on this show and elsewhere that would see that maybe we are a dying society, and COVID has made that pretty evident for a great many people.
Bruce, I have a question.
Yes.
I have a workshop, and it's in terrible condition.
Yes.
There's tools not put in their drawers, not put in their place. drill bits, from the front end to the back end, it's a mess. I hope to get my boys, who are all relatively grown up, like 18 plus years old, to help me clean that shop from one end to the other. How do we clean up all of these regulations that are in such a mess, as compared to my shop?
Yeah, it's a very good question. So let me just take a step back from that question just for a minute. And I want to reframe what we're talking about. People think that the law is a concrete thing, that the rules and the statutes are the rules, that the rules in the Constitution are the rules. And that's just not the way it works. The law is the law is a system of making political decisions, justified with the trappings of the law, to make it look as though there's something more to it than that. So, for example, let me give you an example. In the Constitution, as everyone knows, we have a right to free speech, along with a whole bunch of other rights. And we read that document, it says we have a right to free speech. And therefore we think we have a right to free speech. That's not what it means. Because it's stated baldly. And so we can tell that simply by imagining a situation. So if you go up to somebody on a sidewalk and you tell them, I'm going to stab you unless you give me your wallet, you've spoken. That's speech. And the charter says free speech is protected. That speech is not protected. That's an assault. You might be charged with a criminal offense. And the point is this, that statement of your right contained internal limits, and nobody knows what the limits are except the court, who gets to say what the limits are when the case comes to them. And, it might make sense that we're not allowed to threaten imminent violence, but our right to free speech includes all kinds of other limitations as well, which means that the governing rule is not the rule you read in the Constitution. It's in what the court tells you that rule means. And that is the way it works throughout the system. And so what's happening, the way the system works is it gives certain people, courts, but also officials and politicians, the power to make decisions on our behalf. And the legal system is providing the trappings that give those decisions legitimacy. Everybody thinks, oh, well, that's okay then, because that's what the court said. Well, okay, but the court said something today that was different than what it said yesterday. Yeah. And the existence of the system hides the fact that a lot of this is pretty random and pretty arbitrary and depends upon the person that you get making the decisions. So I don't want us to give the system more credibility than it deserves. We have it. It functions well some of the time, and it has functioned well over a period of time. But it hasn't worked well at other times, and in my opinion, COVID was one of those times that it didn't work very well. So to your question about cleaning it up, there's lots of things that we could do. Lots of things that we could do if we had control of the system. If you had control of the legislature, and or if you were a judge, especially on the Supreme Court of Canada, there's a lot of things that could be done to fix it up. But you'd need to have that political power to do it. And the people who have that power right now are not interested in cleaning it up. If you think about the legal profession, for example, the law has been obscure and complicated, complex, and difficult to understand for a long time. And the legal profession has not been particularly perturbed about that, partly because that makes them the high priests. That means that they understand it and nobody else does.
Yes.
And that's the kind of situation you want to be in if you want to be a high priest.
Right.
If we had an ideal legal system, it'd be one where it would be much easier, maybe not completely, but much easier for everybody to more or less understand what the principles were and to understand how they should govern themselves to stay out of trouble. Right now, that's very difficult to do because you never know what the rules until after the fact. So there's a great deal that we could do, but it's very difficult to actually get done.
So why does Canada have a constitution?
The theory is that the Constitution is the structure of the government and the country. So, for example, one of the things that our Constitution does, the BNA Act, the Constitution Act of 1867, is divide powers between the federal government and the provinces. There are sections in there that say provinces have the power to do this, and the federal government has power to do that. And that's the way the federation works. The Constitution are the rules for what the government is allowed to do. And so that aspect divides powers between the levels, and then a bit like the Charter of Rights limits what governments can do vis-a-vis their citizens. That's the theory. It is, if you like, the architecture of the legal system. Now, as I've said, the difficulty is that what the Constitution means is really in the hands of the courts. And there are lots of situations in which you'd think you see a provision in the Constitution, and you think, well, that's reasonably clearly stated. I understand what that means. And then it goes to a court, and the Supreme Court of Canada, for example, says, oh, no, that's not what it means. It means this instead. So again, it's the text of the architecture of the country and the legal system, but you have to be careful because what you think it says is not always what it means.
So, Bruce, we have a constitution, but the UK does not have a constitution.
It doesn't have a written constitution. It has
doesn't have a written.
Not like ours. They have a largely unwritten constitution. It's still a constitution, and note what that means. That means that their courts are even more able than ours to decide what the Constitution consists of because there's no text.
Right. Now, but of course, with the UK, they don't have any provinces, or they're not but are there? Do we see this more like, I'm not sure what it is like in Ireland, for example? Do they have a written constitution or not? Or is the UK the outlier on this?
Well, the UK is the outlier certainly within the common law Commonwealth. I mean, if you think of other countries like Canada, like Australia has a written constitution, although it does not have a Charter of Rights. The Americans, of course, have a written constitution that includes a Bill of Rights. If you like, the Americans are the archetype of countries that have a written constitution that includes a Bill of Rights. And if you like, and for my money, the Americans have the constitutional architecture that has probably worked the best over a period of time because they have real separation of powers between the branches of government. We do that. We have that too. And so does the UK in principle. Separation of powers means that you have these three branches of the state: the legislature, the executive branch, meaning the ministries, the ministers, the agencies, the commissions, the departments, and so on, and the courts. Legislature, executive, and courts. And the idea of separation of powers is that each one of those branches does a different job. The legislature makes the rules in statutes. The executive executes, which is where the word comes from, executes the directions in the statutes. And then the judiciary adjudicates. Again, that's where the word comes from. The problem in the present era is that each of these branches are starting to do the jobs of the others. But let me go back to the U.S. for a minute. The one respect in which the U.S. has a more acute separation of powers than we do is that they actually have a clear separation between the legislative branch, that is Congress at the federal level, and the executive branch, which is headed by the president. In our system, the Westminster system, which we share with the UK and Australia and New Zealand and so on, the same people are at the head of the legislature and the executive. In our case, the prime minister's office, the cabinet, also sit in the legislature. They direct the legislative program as well as the executive branch. That doesn't mean there's no separation of powers between the two branches. It just means it's a lot muddier than it is in the U.S. system. But in any event, I like the U.S. system, partly because partly because the U.S. system is designed in part to create gridlock. And gridlock is what you want if you want protection from an overreaching government.
Bruce, can I
We
ask
just
you a
spoke about
question?
that. We just spoke about that in our very first episode.
Efficient
Bruce,
government.
wanting to have an inefficient.
That's right. That's
legislative.
right.
I would like to ask about how the presidents of the United States over the last half of my lifetime, I'm mid 50s.
Yep.
Have the presidents have been using their executive orders
Right.
to circumvent the decision making of Congress. Can you elaborate on that?
Yeah, sure. So if you look at a typical statute today, either in the United States or in Canada or elsewhere, you will find probably a delegation of power of some kind. Not in every single one, but typically you will. And what I mean by that is this: the legislature has passed a statute that grants the power to make rules to some part of the executive branch. It might be cabinet, it might be a ministry, it might be a commission, and so on. The president and or one of those agencies is using the delegated power given in the legislation to make executive orders. In other words, it's not exactly beyond the powers of the president to do this. I mean, sometimes it's questionable. But if Congress had not delegated any authority, then the president the president has a few inherent powers, but not as many as he has now because of all the legislation granting executive authority.
I see.
Right? And so, in a sense, let's just take a step back. Part of the reason for the separation of powers idea, part of the reason for having a separate legislative branch, a separate executive branch, and a separate system of courts is so you have checks and balances.
Yes.
Right? They have power. These have power. These guys have power to do these things, and these guys have power to those things, and they will check and balance each other out, and that's fine in principle. But part of the problem in the modern era is that these three branches are more or less on the same page about big questions. I don't mean they don't have disputes between them. They certainly do. But in the big picture sense, there is kind of a consensus about how government's supposed to run. They all believe in a managerial state. They believe in the idea that in the modern era, we need a government filled with experts and technocrats in order to make our way through life. And so, for the most part, the legislature facilitates that idea, the executive executes that idea, and the judiciary, with some exceptions recently from the U.S. Supreme Court. But for the most part, especially in this country, our courts believe in that idea too. And so they, over time, have been inclined to defer to the authority of executive agencies and cabinet and so on to do as they think best in the interest of this managerial state idea.
Well, it strikes me as dangerous that whether it's Canada or the U.S., that the prime minister or the president has the power to make law all on their own.
Yeah.
Without going through the legislative process of accessing the will of the people. And I think that's been growing like weeds in my cornfield without check. And it concerns me. So
I agree with you. But I would say it's even worse than that.
Okay.
So when you have the president issuing executive orders,
yes,
instead of Congress passing legislation, that's not great. I agree with you. But worse than that is this: you have under the president in the executive branch all of these commissions and agencies and so on, and bureaucrats that staff those bodies who are essentially powers unto themselves. Not even the president can tell them what to do sometimes, and the president cannot dismiss them. So, for example, take the Federal Reserve, the central bank in the US, or our Bank of Canada, right? They pretend to be independent. What they mean is we can't be fired, and we can't be directed by the prime minister or the president, if the case may be. Okay. So it's one thing, and it's bad enough. It's bad enough to have the president or the prime minister, who, after all, is elected with a concentration of power. That's bad enough. But to have unelected bureaucrats insisting that they are not subject to political direction is another layer worse, because now you have no accountability at all in the democratic sense.
Right. Go, Randy.
I think Lee, but before Lee jumps in here, there was a real good example of what you just said, and I think we'll pull a video up of it, and that's Jerome Powell from the Federal Reserve.
Right.
So,
good.
If our assistant can get us that video, I think it would be really great to show that proof point. But turn it over to Lee. She's got a few questions for you tonight.
Yeah. So you were talking about the hierarchy in regarding law, and you mentioned the Constitution, the statute, and then common law. Can you explain what the difference is between a statute law and a common law?
Yeah, sure. Okay. So, when students come into law school and they spend their first year, they study a number of subjects, which are not exclusively, but largely common law subjects: contract law, property law, tort law. And when I say they're common law subjects, what I mean is, as I referred to earlier, they are the substance of the law is contained in cases. So in order to figure out what the law is, you have to read through all the cases over time, and those cases reflect the principles upon which those cases were made. And we have this idea of precedent, that the courts are supposed to follow the reasoning of earlier courts in making those kinds of decisions. You can't figure out what the law, what that common law is, by going to the statute book, because the law's not there. So this is law made by courts and not by legislatures. Statutory law is law made by legislatures. And then secondary legislation is made by the executive branch. But if you think about the statutes just first, that is law presented in the form of bills to a provincial legislature or parliament, and the MPs debate it and vote on it. And then you can tell what the law is, because it was very public. It's published as a statute. It's got a lot of sunshine. We can all see what the debate was if we want to. And there you have it. So the common law is very obscure, and for anybody who's not a lawyer, very difficult to make out. The statute is supposed to be very clear in contrast. And then in the middle, we have all this subordinate legislation, which is also not very easy to figure out, because you can find some of it, like the regulations are listed, but a lot of it is obscure and hidden and not that easy to find. So we have a big mixture of these different kinds of laws, and it makes the system, the common law, for a good amount of time, the common law has been very good. I mean, it has been a good foundation of a good legal system for a long time, but right now, for my money, the system is not working well in many respects. It is too complicated. The common law is not clear in many respects as well. The statutes haven't helped, and all of the secondary legislation is making things very difficult to figure out. The lawyers are frustrated. The clients are frustrated. The courts are overwhelmed. We have a lot of problems.
So can you explain the difference between the rule of law versus rule by law? Because I know you mentioned this yesterday, and I think it's
right.
very interesting. And which one does Canada base their laws around?
Right. All right. So we all think we live in a country governed by the rule of law. And so do our partner countries, the UK and the US and so on. The rule of law is an idea. And if you read different legal philosophers, they'll tell you that it consists of a slightly different list of things. But generally speaking, the rule of law is the idea that the state is limited in its powers. It's limited to doing things in a certain way. So, for example, the idea I referred to earlier, the separation of powers between branches of the state, is part of the rule of law. There's another idea that suggests that to comply with the rule of law, that laws should be fixed and announced beforehand, so we all can tell what they are. Part of the rule of law is that everybody is subject to the same law, both those who are governed and those who do the governing. The rulers are subject to their own law. Okay, that acts as a restraint on government, because complying with these ideas is a pain in the ass. It's inconvenient. It makes it slow. You're obligated to follow your own rules that you set out, and sometimes that's a nuisance. And so, what has happened over time, although you won't hear very many people dismiss the idea of the rule of law, everybody says the rule of law is important, but we don't actually follow it anymore. What we have instead is, as you alluded to, a different premise, which is rule by law. And by that, I mean this. The law is now used as a tool by governments, and especially the executive agencies, to create rules on a dime sometimes to herd and direct people to do things that these agencies want them to do. In other words, governments have become agile. And they want to be agile because they think that their job is to respond as quickly as possible to ongoing social problems. Okay? That is not the rule of law. That
Bruce,
is
can you
rule by law.
provide Bruce, sorry to interrupt.
Yeah.
Can you provide a
Yes. One of my favorite examples is during
Okay.
COVID,
Thank you.
right? So you remember what happened during COVID? You had the premier or a public health official standing behind a microphone on a Tuesday saying, this week, the rule is going to be this. Okay? That's rule by law. That's not the rule of law. That is officials making stuff up on the spot, changing the rule from yesterday to a different rule tomorrow.
Right.
Okay, that's agile government. It's not rule of law compliant. They can do that because the legislature has delegated them authority to make things up on the go. And when you are able to make things up on the fly, that means, by definition, really, that you are not subject to your own rules. Because if you find that you've made a rule that's inconvenient, then you can just change it, right? Without going through this long, laborious process of introducing a bill and debating it and voting on it. That takes a long time.
Yep.
And governments don't like to do that. So those who govern, they usually won't admit it, but those who govern do not like the rule of law because it gets in the way of doing what they think is their job. And they're missing the whole point. The whole point of the rule of law is to prevent them from doing exactly that.
Well stated, sir. Thank you.
I think we also have that little clip just to as a proof point of the earlier conversation of delegated authority. Can we pull that clip up of Jerome Powell from the Federal Reserve in the United States?
Some of the president-elect's advisors have suggested that you should resign. If he asked you to leave, would you go?
No.
Can you follow up on, do you think that legally you're not required to leave?
No.
Do you believe that the president has the power to fire or demote you, and has the Fed determined the legality of a president demoting at will any of the other governors with leadership positions?
Not permitted under the law.
Not what?
Not permitted under the law.
Right.
So
Exactly. So. Yep.
Just a marvelous example of how they created the Federal Reserve by statute.
Yes.
And it is a subordinate body. It's supposed to be a subordinate body to Congress, but it isn't. Neither Congress nor the executive can remove the Federal Reserve chairman.
Yes, and in fact, this problem applies more broadly across the public service, both in Canada and the United States. You know, people may think, oh, well, he's the president. He can hire and fire anybody in the government. It's not true. There is legislation in the States, for example, that prevents the president from doing exactly that. This is where the deep state comes from. These people are literally insulated from political control.
Well, just as a follow up to that as well, before we get on to the next one, is people might not be aware that as an elected member of the legislature, I was not permitted. No member of the legislature is allowed to lodge a complaint against a member of the bureaucracy.
Right.
There is no mechanism available to initiate a complaint.
Yeah, they're trying to keep the politicians in their place.
Yeah, it's not just Jerome Powell who is protected.
Right. Exactly so. Yeah.
So there's a lot of people in several groups in Canada that promote pseudo law, or they say that Canada is a corporation, and some of these might be the Freemen of the Land, or Queen Her Majesty Romana Didulo. What would you say to these people who believe in these ideologies that the law doesn't apply to them because they are the freemen of the land, or this, like I said, the pseudo law?
Yeah. It's a lot of wishful thinking.
Yeah.
Let's put it this way. In the law, the proof of the pudding is in the eating. And by that, I mean, to actually test these theories, you need to be in a courtroom. And I think you will find when you try to use these theories in a courtroom, you will lose, hands down. Let's put this another way. The law is what the courts say it is. Why is that? Because the courts have control of the state's force. What the courts say is the order that will be enforced by the state's monopoly of violence. And if you have control over that, then you have the power to declare what the law is. Now, a lot of these theories are based upon historical theories or facts that people think they found out, or things that are missing that people think they should be in there. And that's all very well. And I'm not really versed on the particular historical facts that some of these theories are based upon. The point is, it doesn't matter. If you go into a courtroom and the court does a certain thing, that's the answer. And it doesn't matter if it's wrong. When the Supreme Court of Canada makes a decision that, some people like me say, well, they've made a big mistake here because it should have been this way. I mean, okay, fine. We can say that. We can say the Supreme Court of Canada was wrong. But we don't mean that what they said is not now the law. Because it is. It might be wrong, quote, wrong. It's now the law because the Supreme Court of Canada is the highest court and nobody can overrule it. So we might not like it, but the law is based upon authority. It is not based upon history, primarily. It is not based upon logic, primarily. It is not based upon justice, primarily. And it is not based upon morality, primarily. It is based upon authority. In other words, the most important question in the law is not what the rule is or the outcome. It's who gets to decide what it is.
Okay, Bruce.
Randy, I
You've-
think, Randy,
you've
you
led-
have an example there
you've
someone that was close
Sorry,
to
guys.
Yeah, no, there is a couple things that come to mind there, Bruce, when you're saying that, and I think in large part it has to do with the preponderance of law. The law has become too confusing and for most people to grasp, and they're looking for some simple way to try to make sense of a very complicated system. But there's two cases I want to bring up on that. One was I remember at one time in the legislature, people came up with this idea that they could introduce a petition of right into the legislature, and this would compel the government to act in a certain fashion because that's what a petition of right. It has a very long, old historical evolution, but we don't have to petition right anymore. The closest thing that we have is now a judicial review.
Yes.
So that tool has been long abandoned, and you can't take out an old tool that has been repealed and just make it live again. But I had another example where I had a fella. This is getting near 20 years ago. He had not paid his property tax. He was a free man on the land,
Right.
And it wasn't far from me, over by Smith Falls, and he found an obscure section in the Federal Currency Act that said money is a promissory note, and he took that definition, and for about 5 or 6 years, he was paying his property tax with a promissory note.
Right.
He'd write out a little note on a piece of paper and hand it in and said, I promise to pay you.
Right.
Anyway, we've got the clip up here on the screen. The bailiffs and the OPP and whatnot came to seize the property because they weren't honoring his IOUs.
Right.
And anyway, this fella ended up shooting the OPP officer. Unfortunately, he survived, but that fella took the free men on the land concept to its inevitable conclusion, and he's been in penitentiary institution ever since.
Right. Right. Yeah.
Probably will never get out.
Right. Sure.
So, but those are a couple of firsthand examples of pseudo law in play that, and like with the first one, the petition of right when it was introduced was laughed at.
Right. Right. So there's an ongoing philosophical debate about whether rights are inherent in your being, or whether or not they are granted by governments, granted by the state. And the thing about that debate is that they're talking past each other, in my opinion. Philosophically, sure. I mean, yeah, as human beings, we all have inherent rights, or at least the expectation of inherent rights that comes with the fact of being alive. Okay. That is not a legal question. The legal question is, what rights can you enforce in a court? That's the legal question. If you go to a court and say, I have a right to X, and the court says, nope, then you don't have a legal right that you claimed. It doesn't exist in the law. It might exist philosophically, but it doesn't exist in the courtroom. And that's the legal question. You can't live your life in the law by relying upon philosophical ideas if the courts don't agree.
Yeah.
Bruce?
And I think that's the other thing that goes with that is to live that life in that with that philosophical idea to that degree, like the free man or the promissory notes or whatever, invariably leads you to living outside of civil society.
Well, listen, I think some people would be happy to live outside civil society if they were allowed to. I mean, and this is part of what some people are trying to do. They're trying to say, look, I'm just going to go over here and be outside the system. I'm going to declare myself as outside the system. So please just leave me alone. And I respect that. I respect that aspiration. I really do. The problem is that the system's going to say no. They're not going to allow that. That's exactly opposite to the whole idea. The whole idea is they have sovereignty over the territory of Canada, and they will enforce their rules on everybody. and you just can't excuse yourself like that. I mean, I'm sorry that's true,
Yeah.
but that's the way it is. That's because, as I alluded to earlier, that's because the system of law is based upon authority and more upon authority than anything else. Authority and the monopoly of force.
Bruce, what impact is as we saw in last week, the across the country, statements of uh, you know, we're living on unceded territory,
Right.
and how will that impact our property rights as I don't have it this week, but last week I
Yep.
had a deed from George III, King of Brittany.
Yep.
That my great grandfather
Yep.
owned the property that I'm sitting on right now. So
Yes. Well, this is a especially acute problem if you happen to live in BC right now. Because the BC NDP government, before the election in any event, seemed to be determined to not directly transfer fee simple, that is ownership of title of various tracts of land, but they're close. They're transferring control and an Aboriginal title to or co-management of that sounds like the plan of a very large proportion of British Columbia.
wow.
People think that their property rights trump the government's laws. That is not true. There is nothing. Let's put it this way: there is nothing that trumps the legislature's ability to pass laws, except for the charter, if the court agrees with you. But there are no property rights in the charter. If today a provincial legislature said, we are taking the property of all the people in this community, and they passed expropriation, and they passed a statute that said that explicitly, then that's what the law is. Because there's no constitutional right to it, and the legislature has supremacy otherwise over the laws that it passes. And so our property rights are subject to the democratic process, if you like, and to the legislator's judgment about what kinds of property rights we should be allowed to keep. And that's a terrible thing in my books, but that is the reality. And the reality is important so people understand the threat that exists to the way that they think their lives should unfold.
Yes.
So I noticed we do have a super chat, and I just want to say that we will get to that at the end. We're not ignoring you. But we are reaching the last half hour here, and we will get to the website questions as well. But just a few more questions before we get to those. So if we understand that proximity equals more laws, what does that look like in a 15-minute city?
Okay, so proximity, you mean more people living in close quarters with each other in an urban area?
Yes.
Yeah, so on the 15-minute cities thing, for my money, the 15-minute cities is a good example of the insidiousness of the administrative state. And by that, I mean that the way things happen now in our system is not that the government comes along necessarily and says, right, all you people, we're now going to put in a new draconian rule. Now, that does happen like during COVID, right? But as often as not, it doesn't happen that way. It happens much more insidiously. And by that, I mean gradually, innocently, slowly, in a non-mandatory way, so that people adjust to the idea. So a 15-minute city doesn't start out as a draconian idea. We are not going to get next year a rule that says you can't leave your city. That's not the way it's going to work. The 15-minute city idea is a planning idea. The planning idea is that local authorities should plan their communities when they're giving development permits and so on, so that everything's within a 15-minute radius. Schools and parks and shops and so on. That's doesn't sound like such a bad idea, right? But once you've got that, then it's possible to keep you in that area because you have everything you need, right? So, and other kinds of things are going to work this way as well, or potentially anyway, like digital ID, like digital currency. You introduce an idea, it's for convenience. A digital ID will be for convenience. You'll be able to show your ID to the police officer or to the person at the counter, not by showing your driver's license card, but by showing your phone, a QR code on your phone. Okay. It's just for convenience. It's not mandatory. You can do it the old way if you want to. That's how it begins. But then time goes on and the old way becomes old and the new way, it becomes more efficient and cheaper. And eventually the old way will be more difficult to obtain. And eventually the digital ID will be mandatory because we don't want to do it the old way. Okay. And now the government has a way to track you.
Like
right?
cash.
Like cash. Like digital currency works the same way. And it's sort of in process now. You don't see yet the government saying that bills are illegal, but it's coming because we accept the steps along the way. And once you are down that route, it's very difficult to resist the final step. You sort of have to resist the first step because the further down you go, the more difficult it is to get back.
Yeah. Once you've already become acclimatized to that convenience,
that's correct.
It now becomes, that's the hook of dependence, essentially. And I was speaking with a young girl from Ukraine who was over at the house a week or so ago, and their passports are on their phone. Everything,
yeah, that's right. Yeah,
it's already there, and of course in the Ukraine, the state doesn't want to know where you are because they've also have conscription laws and a few other things that are going on.
Well, they also going to want to know what you have in your bank and where your bank is, so that they can do what they did during the convoy.
Yeah. So maybe we'll. I don't know how long that video is. If we, I did a little metaphor of the 15-minute city with here at my home. Can we put up that little video and see what it looks like? That doesn't look like the right video. Maybe we don't have the right video. We'll see if we get that. But anyways, all that is, it's sold through the idea of convenience. And I've heard from many people that why would we not want to have everything?
You're right, Randy.
Within 15 minutes of you.
Yeah, but you see the other aspect of 15-minute cities. You see what they're doing. They're doubling down on the idea that our community should be planned.
Mm-hmm.
Right.
Yeah.
And town planning has been around for ages, but it increases over time the degree to which local authorities think it's their job to determine how every piece of land is being used. So this is just part of the increasing dominance of the state in everything. And let's not lose sight of the fact that every one of these levels of government, whether it's your most local government or whether it's the federal government furthest away from you, it is all part of the same thing. It's all part of the state. Municipalities are part of the executive branch of the province. They're created by the province, right? So if your local authority suggests that this is just local democracy and they're just doing it because they have the local authority to do that because all the people around them agree, they are a branch of the provincial executive. And they have authority only because the province has given it to them. And in a different world, they would not have the ability to tell everybody what to do with their own land.
I've noticed a lot of people. Oh, go ahead.
We'll see if we can get that video up. I think we might have the right one. I'm not sure.
How do I get to that different world?
You have to you need a critical mass of people to reject the idea of a managerial state.
Yeah.
You have to get people to say, you know what, the way we are governed now, I don't want it that way anymore. I don't want
So-
people with authority and expertise or who claim to have authority and expertise telling me what to do.
Randy and I worked on that 20 years ago.
I know it's a long time, and it takes a lot of effort to persuade people who are. See, most people have grown up under an administrative state,
Yes.
and they think that's what government is. I mean, if you went to somebody on the street and said, you know, we shouldn't have all these people in the government making rules and policies and so on, and they might say, I don't understand. What else is government for? That's what they think it's for. And so we need a different framework altogether,
Right.
a different concept of why we have a state, and that's a big job.
Yes, it is.
All right, let's go with that video now. It's see if we get the chickens into play.
What is a 15-minute city? I have a very special clip as we travel off-site to examine and visualize what our futures look like in a 15-minute city. If you want to see what I can't show you on YouTube, be sure to watch my weekly show, Scuttlebutt Lodge, on Odyssey, Facebook, and Instagram. Links are in the description below. Enjoy. I've had a lot of people asking me about 15-minute cities, and I've seen all these people who extol the virtues of 15-minute cities, that they're great things, and then other people who are very worried about what a 15-minute city is. And I know we have a proclivity in our culture, in our society today, that we have to rely on expert models before we can make a decision if something's good or bad. So I decided that I would create an expert model to help visualize to people what is a 15-minute city. So come on in, let me show you what a 15-minute community looks like.
Well, I'm excited to see this, Randy, because you always break things down into nice practical ways, right?
Here we go. These residents of the 15-minute community, they're not locked in, but they just stay there. They're free to come and go, but they don't. So let's take a step inside. Everything they need in their life is right here in their 15-minute community. A water bowl, a feed tray. They own nothing, but they are exceptionally happy. And you know how happy they are is by how many eggs they produce. And it's so wonderful because I get to take everything that they produce and they just keep producing. So let me go in here. And here we go. Each of them have their own house. Now, in a 15-minute community, you don't get a lot of variation in housing. They're all pretty much the same. But we can take a look and collect their production. There's a few. There's a few more. And there we go.
And they're none the wiser.
And they're happy.
Yeah.
I get to take what they produce. They're free to come and go, but the world is so scary for them out there. They will never leave. I don't have to put a fence around them. And here we are.
It's an ideal world. I don't see anything wrong with it. Everything is provided for them. They're cared for. They're happy. They're together.
Yeah.
It's all convenient.
What? So anybody who wants to understand what a 15-minute community is, here you go. And there's only one boss. And that boss provides everything for them.
Well, they're lucky to have you, Randy.
But I should give them some food. And they know when it's dinner time.
Hey, Come on, girl. Settle down now.
This is your future in the 15-minute city.
That was a fun little, but you know, I do think I think it's a good metaphor, a good illustration.
Sean just has a chicken now.
I brought a friend to the chat.
You took one out of the 15-minute community shot.
Yes, I did.
So I see here in the chat a lot of people are saying, well, what can we do? What can we do to prevent, what can we do to save ourselves from the claws of the machine, so to speak?
Well, so number one, you have to stay out of the way as best you can. But if you really want to change it, you have to get together with your fellow citizens and decide you're going to change the way this country works. And that is as everybody on this call knows, that is a big, huge call. That's not easy to do, but it needs to be done.
And I think we should say that there are small groups that are getting bigger, and small groups that are doing things to operate. They're still operating within the law. Don't get me wrong, but they are taking matters more into their own hands. We've seen the big increase in these co-op and Christian schools and homeschooling, and various initiatives like that, as one example.
That's all good, and I think that's terrific. I hope people will continue to do that kind of thing. But we should acknowledge that the United States has a moment right now.
Yeah.
It has managed to at least give itself a chance, and I don't know what's going to happen. Time will tell. And I'm not a big one for believing in political saviors. However, that country has a shot now at least pushing back on the dominance of its deep state.
I think it's a sea change.
We'll see what happens. And it's not going to happen in the same way in Canada. It's not, because we have a different culture. We have a different political culture for sure. But it's not impossible. That the next little while is going to demonstrate what the political possibilities are south of the border, and if something goes well there, then things open up here as well. So cross your fingers.
Yeah, I think there is, what we're seeing in the States. Obvious, it's going to have some impact here. I think, but I guess the thing I would say is, for the Canadian voters is, don't be like those chickens in the 15-minute city. And yeah, you might have to do something a little bit scary, like change who you vote for, and change how you interact with the political system.
Well, don't just change who you vote for. I mean, yes, do that, but also change the way you interact with your fellow citizens. Like in Canada, people tend to be much more reticent about saying what they think.
True.
In a lot of places in America, that is not the case at all. People have open arguments about things without getting vicious with each other. They are much blunter about their political opinions. And that is something we are not good at generally in this country, and we have to fix that.
Well, I was always told growing up that the two things you shouldn't talk about are politics and religion, because it causes strife. So I'm sure many other Canadians were raised the same way, and just be polite and just don't talk about any controversial things.
And we get what we deserve.
Exactly. Yeah. We're reaching the last 15 minutes here of the stream, because I know you guys are going over to Twitter to join a Twitter space after the show at 9:30. And we have a super chat that came in from Andrew. He says, Bruce is a great guest. Thank you, Randy. And so thank you very much for that super chat. That's awesome. And I think we're going to go to some website questions that were submitted to Randy's website, randyhillier.com/ask a question. And I think you guys have those if you wanted to select a few from there.
Yeah. So there's a few here, Bruce, and I'll throw them out, and we'll see who's wants to answer them. Here's one I think that everybody, and it's about the Mosley decision, and it reads: as a legal concept, um, the decision by Justice Mosley, the federal government did not meet the burden of proving that the circumstances warranted the invocation of the Emergency Act.
Right.
What should be the burden of proof, if any, on the authorities before implementing these massive suspensions of charter rights? Should not the burden be in the other direction, in suspending rights of a fundamental nature protected under the charter?
Mhm. Right. Okay, so first things first, as the question alludes to correctly, the conclusion in that case about the Emergencies Act was that the thresholds, the requirements of the Emergencies Act itself were not met. Okay, that has nothing to do with the charter. That's all. That's inside the act as passed by Parliament. Okay, and that's absolutely correct. I think the judgment was exactly right on, but it has nothing to do with the Constitution. The question suggests or asks, what should be the burden upon the government before they suspend charter rights? Well, if you suspend a charter right, then your burden is to show under Section 1 that it was a reasonable limit. But that begs the question. In a lot of these COVID cases, it begs the question about whether or not the charter rights were actually breached. And in many cases, the court said no. Now, the person who asked the question and me and many of you may disagree with that. But that's my point about the power of the courts. If the courts take the charter and they interpret the words and say, well, that's not what it means. Even if to us that seems like it makes no sense, it doesn't matter. They have authority. And if the government has done something within its power, within its division of powers under the BNA Act, and if the public health officials, for example, have done something within their statutory mandate, and if the court says that no charter right was breached, if all those things are the case, then the government does not have to prove anything. It does not have to prove that the data was in their favor. They do not have to prove that the vaccine works. They do not have to prove that nobody was harmed. They do not have to prove anything. That's because the system is based upon authority. If the legislature passes a statute and delegates authority to a bureaucrat, and the bureaucrat acts within that authority, then that's the end of the story.
So I want to tie in that question with one of your initiatives from last week, Bruce. And many people will be aware that Alberta has introduced a provincial Bill of Rights.
Yes.
And you've provided some commentary on that. And there's two things I think. One is that we didn't touch on tonight that I think is important for people to know is that each province can amend the Constitution with respect to their jurisdictions. A lot of people think that the Constitution has to be amended by the 7 provinces and 50% of the population. Right. That doesn't apply to a province amending its own constitution and incorporating it. Right. But you had some comments on ideas on how to toughen up. We see Danielle Smith basically replicating the failures of the Charter of Rights in her new Alberta Bill of Rights.
So listen, I want to salute Danielle Smith for her initiative at going down this road. I mean, I think it's a good project. It's just that if you are doing what they're trying to do in Alberta, which is to pass a bill as a statute for a statutory Bill of Rights, as you say, That is not a constitutional document. You could make it one if you decided to go that route, but this one is not designed to be that. But let's make a more fundamental point. What do bills of rights do? Whether it's a statute or whether it's a part of a constitution like the charter, what does a bill of rights do? And we can state it very simply. A bill of rights takes power away from legislatures and gives it to courts. That's all it does. It is the legislature saying to a court, here are the limits on our power. We're going to give you the power to enforce them, to interpret and enforce them. You can say what they mean, and then you can prevent us from doing what we want. So let's put it this way. If you happen to believe in legislative supremacy, that is, in the balance between legislatures and courts, if you don't like courts having power, and if you prefer the democratically elected legislature to have all the power, then you do not believe in bills of rights. Because the function of the Bill of Rights is to take power from the legislature and give it to courts. People think, well, but they're describing my rights. They're giving power to me. No, they're not. Because those rights are dependent upon enforcement by a court. Those courts have the power to interpret what they mean. So you are just taking power from legislatures and giving it to a court. If you don't want to do that, then don't have a Bill of Rights. But in the case, in the case of the Alberta Bill of Rights, here's the problem. If it's a statute, people think that you pass a Bill of Rights, and therefore, from now on, the legislature is committed to what the Bill of Rights says and can't breach it. It's a statute, though, so that's not true. No legislature can bind a future version of itself. So if the next Alberta government comes along and says, oh, you know what, we don't like that Bill of Rights, we're going to repeal it, they can. Or we're going to amend it, they can. Or we're going to pass a new statute that breaches the Bill of Rights, and we're just going to say in the statute that it applies notwithstanding the Bill of Rights. They can do that too. No legislature can restrict the powers of a future version of itself. And that is an inherent limitation of passing a Bill of Rights as a statute, and we must accept it and acknowledge that's going to be the limitation. If you expect more than that, you're not being realistic.
I think there's something else, though, Bruce, that I should just add in. Like, this may not be as clear, but I think it's true. Is one of the other elements of the law and the legislature passing the law. The law is also, there's an educational component of the law within society as well. That now we're conveying to the population what it is to be a Canadian. We're enunciating that Canadians, or in this case, Albertans, are this sort of society. There is an educational component.
I am not. Don't get me wrong. I'm not saying there's no point in having it. I think it's a good project. And what you're referring to is, I think, one of the two main reasons to have it. Because if you create one, then you create a political liability for a future government to do as I described. Right? You have a Bill of Rights. Everybody has embraced it as reflecting the identity of the province. A future government comes along and says, oh, we're going to repeal that, or we're going to breach it. I mean, that now is politically dangerous to do. So you've created a political obstacle. It's not a legal one. They can still do it if they really want to, but hopefully there will be a political price for doing that. The other reason for having one of these things is not so much to prevent a legal impediment to the legislature, but a legal impediment to the executive branch. Right? So the legislature can get around it by saying that's what they're doing. But in the absence of that kind of a statute, the Bill of Rights should bind the executive branch, cabinet, ministries, departments, and so on, because it's a statute. A statute gives the marching orders to the executive branch. There's no other statute that contradicts it. Therefore, the executive branch now cannot create regulations or policies or guidelines or orders that breach the Bill of Rights. And that's a good reason for having it.
Bruce, I think maybe Pearson back in the 60s, Bill of Rights, federally.
Yes, yes.
What happened
Canadian
to
Bill of
that?
Rights. Yeah, Canadian Bill of Rights. It's so people put a lot of stake in the Canadian Bill of Rights because the Charter has fared so badly. But the Canadian Bill of Rights is exactly what we're talking about. It's a federal statute. It applies
Yep.
only to federal legislation, and its record is very poor. It was not effective at preventing government action. And in
Yes.
fact, in large part, the courts basically said that if a future statute came along that was in conflict with the Bill of Rights, then Parliament had the power to legislate, and they did legislate, and therefore the Canadian Bill of Rights didn't prevent them. It's exactly what I'm talking about.
Yes.
The Canadian Bill of Rights is not the good model to base your conception of rights on. It didn't work.
So if the federal government can't do it, then obviously a provincial government can't do it.
Yes, and so well, they can do it. It's just that if you want a different outcome than the Canadian Bill of Rights suffered, then you need to word it differently and hope for the best. You cannot guarantee it because you're putting the fate of that statute in the hands of the courts.
Yes.
So we've got another question here, and I'm going to paraphrase it. It's a lengthy one, but we saw through COVID that many of our regulatory bodies had become captured by the very pharmaceutical companies, whoever. They've been captured, and we're now not serving the, people might say, not serving the interests of the public, nor serving the interests of the profession that they were regulating. So the question is, has that happened to the Law Society as well? Is the Law Society captured by other functions or other entities?
Well,
or is it the same pressures?
So this is the question of professional regulators, and professional regulators are. Let's start with this. Professional regulators, like municipalities and like cabinet and like ministries, are a part of the executive branch, even though they are run by the professions themselves. The medical regulator, run by doctors, is a part of the state, part of the executive branch. The Law Society, it's run by lawyers. It is still part of the executive branch of the state. Why? Because they get their powers from a statute. Now, are they captured? Well, in a sense, they are captured by an idea or a group of ideas that made them do what they did during COVID. I mean, the medical regulator, for example, was determined to prevent doctors from contradicting public health orders. I doubt very much that's because, somebody from a pharma company called them up and said, here's $1,000. I want you to do this. That's not the way this thing works. They get captured by a set of ideas, which essentially constitutes a worldview. And the worldview in this case was that the public health authorities have expertise, and it is harmful under the present circumstances for those orders to be contradicted. And therefore we have the power to tell you what to do because we are the regulator and you are the professional, and therefore you will not do this or we will punish you. I mean, that's a terrible idea. But that's the idea that the regulators now believe in. They believe that their job, for the most part, is to govern the attitude, beliefs, and speech of their members. I mean, we ran into this at the Law Society, not about COVID, but earlier about political orientation. We had a policy that suggested that lawyers were required to sign a statement of principles that endorsed their obligation to promote equity, diversity, and inclusion in order to keep their license. Okay, that's being captured by a set of ideas, and that's why regulators are a dangerous thing, or have become one.
Well, there's been many examples of ideas capturing those with authority, I guess. in the last 4.5 years.
And yes, and the problem is, I mean, the ideas are bad enough, but the problem is the authority. If they didn't have the authority, then it wouldn't matter if they got caught by the ideas. It's the authority that's the problem.
Well, yeah, and that was always I always thought it was absolutely bizarre that the legislatures would delegate and empower a professional body to have the authority to take away somebody's livelihood as a penalty. And I always thought that was very exceptional and extreme, but we saw that during COVID. And they did execute it.
Well, like so many things, though, this starts in a place that sounds like it makes sense, and then it evolves to the place where we are, right? So the place where this conceptually begins is the idea of self-governing professions, meaning that the professions should watch over to make sure that all the people who practice it are competent. That is, they don't expose the public, their own clients, to incompetence and therefore danger. You don't want your lawyer skimming your funds off your trust account. You don't want your dentist drilling teeth if they don't know how. So that idea like makes some sense, right? You want a dentist who knows how to drill, but you begin there and you end up where we are, which is that the regulators now believe that it is their job to govern not just the actual professional competence of their members, but their ideological attitudes about things.
So, well, listen, I didn't get to all the questions. We'll get to more of them next week. I want to thank you very much, Bruce, for joining us tonight.
Yes,
Lee,
thank you, Bruce. It's been
John,
informative.
It's been my pleasure. Thank you very much for having me.
I want to thank Bruce too. Wonderful.
And for those who next week we'll get a little bit deeper into the Charter of Rights and Freedoms with Brian Peckford. And if you'd like to join us, we'll be on the No More Lockdowns Twitter account. It's live and in action right at the moment. And I'll be joining you there for more questions tonight. And hope to see everybody there. Thanks once again, Bruce.
Sure thing.
Thanks, Bruce.
Oh, and I guess we should also say, is there one more thing, Lee? If you want to support the production, press the like, press the subscribe, and share, and help out on the production.
Yes, absolutely. Do that.
Okay, bye-bye.